bienvenue à le Short Circuit, ton podcast de la Fédérale Cour d'Appel. Oh, Zoom excuse! Very sorry, ladies and gentlemen. This is the English version of Short Circuit. I'll start over. Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, or December 6, 2023. We have a special guest here today that I'm very excited to introduce to you. But first, I'm going to welcome on my colleague, Arif Panju. So Arif is the managing attorney of our Texas office. And what most people probably don't know is he is of a Quebecois heritage. So he knows le français much better than I do. And we brought him on today partly because we're talking about a case from a civil law jurisdiction, the great state of Louisiana. And the case from the Fifth Circuit that he'll be discussing has a tinge of its French legal background. So Arif, welcome or bienvenue.
Merci, Anthony. C'est un plaisir d'être ici à Short Circuit. And your French was fantastic. I could share this with my friends in Quebec and beyond. So thank you for continuing to expand the reach of Short Circuit. I appreciate it, and so do all French-speaking lawyers and non-lawyers alike.
Well, thank you. And I hopefully the Quebec folk would be more forgiving than those I've met in France over the years, who I think would not be so hospitable given my pronunciation. But more importantly than all this French business is our special guest. He is Braden Boucek, who is the director of litigation for Southeastern Legal Foundation. So Braden is a proud Tennessean. He lives in the Nashville area. Over the years, he has helped us in a couple different litigation matters in the great state of Tennessee. He's a hardened practitioner for liberty. He's been practicing for over 20 years. And he's coming on today to talk about a case from the Eighth Circuit that has a little bit of all kinds of things going on with what we run into in public interest litigation. So, Braden, welcome to Short Circuit.
Thanks, Anthony. Thanks for having me on. And I'll do everyone a favor by not trying to reply in French, just bearing in mind that my French education consisted of what I learned in middle school in Tennessee in the late 80s, which is probably not the language submersion that you and Arif underwent.
Well, I had 2 years in high school in Washington State, and there weren't a heck of a lot more French people there than Tennessee, I imagine. On a different note, I didn't mention that a few months ago, we talked about a case of Braden's. Some of you may remember the sidewalk case from Nashville, and the question of what kind of bucket or the regulatory takings claim in that case landed in. And that was actually Braden's case that he argued at the Sixth Circuit. So congratulations on that case, Braden. And then tell us about this other one from the Eighth Circuit that you wanted to share with us today.
Thank you very much on the sidewalk case. I think it's I hope it's the important blow against tyrannical infrastructure funding projects from local governments that we all hope it is. But it's truly a team effort. I know that there's a lot of people who litigate on our side who have been involved in those issues for a while. So I do hope it's important. Anyway, let's talk about something in more of the free speech bucket, and that's Parents Defending Education versus Lynn Marr, which was an Eighth Circuit opinion that came out earlier this year. It came out in February. But it's a pretty important First Amendment case on some timely topics. So a school district in Iowa called the Lynn Marr School District came up with a regulation, a policy, and it addressed a series of issues concerning transgender and gender nonconforming students. And what the policies enacted, there were several kind of issues with it. First, it sets forth a process of what's called gender supports for students who might be gender nonconforming, where they would be set aside. They would meet with students or administrators, and I think, critically for purposes of this challenge, it said that the student has the right to determine who will be in those meetings, including whether or not their parent or guardian will participate. And related to that was a provision that kept the students' decisions in the gender support plans pretty highly confidential, including in some circumstances from a parent, unless law required otherwise or the student consented. So that's kind of the first bucket of policies that were being challenged here. The second had to do with the usage of names and pronouns, which implicates speech. And the policy declared that students have the right to make a determination about their names and their pronouns, and that a persistent refusal to respect those could be deemed bullying and harassment and subject an offending student to suspension and even expulsion. So these policies were challenged by Parents Defending Education, which is a membership association, on behalf of a bunch of parents who were in this school district. And there's parents who are interested in challenging the first set of policies and parents who were challenging the second set of policies. The parents who wanted to challenge the gender support plans were parents of students who feared that their children would be targeted as likely gender curious or gender nonconforming and be brought into one of these plans without the foreknowledge of the parents. And then the other set of plaintiffs were more concerned about their students' ability to discuss gender issues, to say things like, I'm not comfortable going to the bathroom with somebody of the opposite biological sex, or to even get in a debate about gender dysphoria or whether or not there are only two biological sexes. So the parents brought a preliminary injunction down below. This was a pre-enforcement challenge, and that's important, and we'll return to that in a moment. But none of these policies had been enforced against any of the students. And as any of us who litigate in any space knows, bringing a pre-enforcement challenge is always pretty tricky. It's bound up in certain questions about whether it's premature or whether there's been an injury, in fact, for a district court to redress.
It's great fun for defense counsel, though.
Oh, yes.
All kinds of these arguments they can raise.
That's absolutely true. And as you, no doubt both of you know, oftentimes the thing you think you're going to argue about in this momentous issue of constitutional law winds up not being the thing you think you're going to argue about in a momentous issue of constitutional law. And instead, you're having a whole bunch of arguments with a government attorney about whether or not you sued us the correct way, including whether or not it was too soon or too late or probably both. And of course, that's what this case wound up being about. Parents Defending Education did not get their preliminary injunction on either the issues relating to the gender support plans or the free speech issues down below, with the court ruling, among other things, that they had just not proven that this would ever, in fact, injure them or had injured them yet. And he ruled it on both the parental rights claim and also on the free speech claim. And then it goes up to the Eighth Circuit on an appeal of the preliminary injunction. And in the meantime, Iowa had enacted a law that prohibited school districts from giving false and misleading information to a parent about a student's gender that would be different from their birth certificate. So now we have another justiciability argument, mootness. So a case that was not ripe because there had not been an injury in fact down below is now being considered for mootness, bringing some sort of quantum mechanics about whenever this case might have been potentially viable. As somebody who has personally lost on ripeness to a trial court, only to have the opinion affirmed on mootness grounds, I can relate.
Wow.
Yes, I know it's quite a feat to be able to occupy that sort of multiverse theory of standing.
It's like a Doctor Who episode.
Yeah, it's like the multiverse theory of standing, right? I'm not sure when to a metaphysical certainty that case ever actually was a live controversy.
It reminds me, I think Teddy Roosevelt once tried to make a recess appointment between Congresses, because his argument there has to be a recess, on January 3rd or whenever it is, when one shifts to another. And I can't remember. I don't know if he won that argument or not, but anyway.
Yeah. Well, the Eighth Circuit ruled that it was indeed moot, the due process challenge to the parental rights. And that had been framed up as a substantive due process challenge. And I want to return to that in a moment. But the district court had ruled that they hadn't suffered an injury because none of them had shown a threat that they were going to be subject to these policies. And the Eighth Circuit just ruled that it was moot. I don't know how much Parents Defending Education cared about it, given the fact that they essentially got a state law that had given them more or less the right. They made some arguments to try to keep it alive, but the Eighth Circuit didn't buy it. The more interesting arguments in the Eighth Circuit sounded around the First Amendment issues. In the lower court had ruled down below that not only was there not standing because there wasn't an injury, but they'd also ruled that this policy would survive First Amendment scrutiny, that it wasn't content-based, that it wasn't viewpoint-based, and it wasn't unconstitutionally vague or overbroad just to have a policy that says you have to respect other people's names and pronouns. And if you don't do that, you can be subject to discipline. And it's easy to hypothesize about what the potential injuries could that from be. I mean, PDE pointed out, look, I might have a kindergartner that calls a biological male who is transgendered him. And is that a failure to respect? I don't know. Or you might have a middle schooler that wants to debate biological males in women's sports or whatever. Is that a persistent refusal to respect someone's gender? And here the Eighth Circuit agreed with the plaintiffs that there was a credible threat of enforcement. And they didn't get into a lot of the free speech arguments, the content-based, viewpoint-based. They just said it's impermissibly overbroad because they've not sufficiently defined with precision what it means to respect a person's pronouns or when it crosses the line into disrespect. And therefore, they found that it was sufficiently chilling to a person's rights. A couple other things bound up in that is within this decision, and I think this is an issue you'll see keep coming up in a lot of free speech issues that are really live right now. The Eighth Circuit says that simply, even though it's obviously fine for schools to regulate harassment or discrimination under their laws and policies, what they can't do is label pure speech to be a form of harassment and bullying and think they're going to sidestep First Amendment scrutiny. I know IJ and myself have both litigated in a lot of these so-called professional speech cases, but we're all familiar with the NIFLA case and the so-called speech incidental to conduct restriction exception to NIFLA. And I think this was an effort to argue that this was at most a speech incidental conduct restriction. But the court took a clear-eyed look at it and just said, anytime you are calling something that entirely consists of speech and labeling that as bullying harassment, it's going to get full-on First Amendment scrutiny. And they also rejected the argument that speech becomes unprotected merely because it's bullying or harassment or could be construed as disrespectful or anything like that. So it's important First Amendment ruling from that perspective as well. Remarkably, there is a concurrence here that reads a lot more like a dissent to me. And it's a concurrence because the concurrence agrees the policy sweeps impermissibly too vague. But the opinion mostly says that the school might have a compelling interest in regulating the speech under the guise of federal anti-discrimination law, which probably applies in these settings. This is coming mere months from the 303 Creative decision, where the Supreme Court says that anti-discrimination laws are still subject to the First Amendment. And I mean, this is really kind of, I don't think, a very challenging proposition for a lot of lawyers. Obviously, if there's a federal regulation or a federal law that implicates free speech, it too is going to get bound up by a First Amendment analysis. You can't have a local school district just saying, well, the reason why I'm violating somebody's First Amendment rights is because the federal government is making me, and then have that become a compelling interest that satisfies First Amendment scrutiny. So that's an interesting aspect to this that I'm sure will be live. The two other things that I think that I'd flag for listeners is first, this is, as I mentioned earlier, a pre-enforcement challenge. And as IJ attorneys certainly know, there is substantial disagreement about when a potential harm is sufficiently imminent to trigger pre-enforcement scrutiny. Right. And the Supreme Court said in a decision called Clapper that the injury has to be certainly impending. And if it's certainly impending, it's very hard for a plaintiff to find the moment before the actual injury to their free speech rights occurs where they still have standing to challenge it. And the district court squarely relied on the Clapper standard and used that to explain why the injury was not sufficiently imminent. Then you get to the Eighth Circuit, and the Eighth Circuit relies on an opinion that came out, I think within a year or two of Clapper, but it's the Susan B. Anthony case, which I'm sure you're no doubt familiar
very
with.
Tiptoed kind of around the Clapper standard and did its own thing.
Yeah, and I think that they were trying to tiptoe around it, as you said, but it's definitely a more relaxed standard, at least in the First Amendment context. But it just says that there just has to be a credible threat of enforcement. And the Eighth Circuit, not mentioning the Clapper standard, not mentioning the tension between the two opinions, just cites Susan B. Anthony and says, we think that showing has been made here because they debatably fall within the scope of this policy, and there hasn't been any official disavowal of enforcement of it from the other side. And so that was sufficient to make a pre-enforcement showing there. But, it's easy to imagine future district courts leaning on Clapper as a way to bounce potential plaintiffs out of court. The other thing that I think is really interesting, too, is this is a substantive due process claim. The parental rights claim is. And I think that these things are just starting to become emergent again. Substantive due process has been in bad odor for a lot of people for a long time. Certainly not for IJ attorneys who understand that substantive due process claims also embrace economic liberty. But there's always been this pushback from some people about whether or not the Constitution protects unenumerated rights, and if they do, if it's under the substantive due process clause or not, and if it does, when those things are accorded legitimate First Amendment scrutiny. And I think that this is going to be a real live issue going forward, because suddenly you're going to have people like Parents Defending Education who are going to be defending more conservative parents. And they're going to have to reconcile with substantive due process, which a lot of the more conservative Supreme Court justices are particularly skeptical of those sorts of claims. And so, I think that that's going to be an issue and a trend going forward. And an oral argument prior to the case getting mooted, there was a lot of questionings about the scope of their substantive due process claim. And I think that just highlights the tension and the need to reconcile, the parameters and come up with a cogent way of identifying both what rights are protected that are unenumerated, and how to determine what the appropriate standard of review from rational basis to strict scrutiny, what those tests are going to be, and how we determine when to apply which test,
right.
Which I think is very much something that is unclear in light of Dobbs and Bruin.
Yep.
I agree. And not in light of Dobbs and Bruin, in light of cases that are much older.
Oh, for sure.
Pierce v. Society of Sisters is pretty clear that you have a fundamental right to direct the upbringing of your children. And in that case, the law being challenged involved a requirement in Oregon that all kids be funneled to the government's schools, even if parents didn't want that. And Meyer v. Nebraska, similarly. So I think, whatever stench of substantive due process that folks may have perpetuated, both, in being hostile to deeply rooted rights or being indifferent to them, or in law schools by caricaturing judicial review and using scary boogeymen like Lochner. I think eventually more reasonable minds will realize that even the dissent in Lochner, the primary dissent, got it right. And the courts in Meyer and in Pierce got it right. And as Anthony knows, unenumerated rights are deeply rooted. They're reflected in state constitutions. They're reflected in the U.S. constitutions. And our framers would have understood them to be so deeply rooted, both at the founding and at the second founding as well.
Yeah, I think as you are well aware, though, the way that the modern legal mind makes sense of Lochner and Meyer and Pierce is to just sort of reconstitute Pierce and Myers as First Amendment cases. And somehow we've allowed the First Amendment, nobody has a problem with the First Amendment getting muscular versions of review. So that's number one. I don't think that is a faithful reading of Meyer or Pierce. They are clearly substantive due process cases to me. That's what the court understood them by. And they embrace the same logic as the discredited Lochner majority. We just are more comfortable with the result. But the second thing is there has always been this issue about defining, how do we define the scope of an unenumerated right? And you can always zoom down with a sufficient level of granularity such that you can say there's no historical tradition to any kind of a right. So, this is starting to become a real live issue in these parental rights cases. There was, I think it was in the District of Maryland, where there was parents who had brought a challenge to school curriculum and said, look, I've got a substantive due process right to control the education of my child. Everybody agrees that that's recognized by Pierce and Myers. But the way the court characterized the right is, sure, but that has never included the right to control public school curriculum. And it all just is susceptible to manipulation about how high level you view a particular right. And I think that is something that methodologically the court's going to have to reconcile in short order.
Yeah. And I'd recommend that folks, recently the Federal Society's National Convention dedicated the entire convention to originalism on the ground. And there is a great panel called Mere Natural Law. It's online. And Randy Barnett gets up to a double ballroom full of people that showed up to listen and learn about natural law. And to a huge round of applause, basically deconstructs this false idea that unenumerated rights should not be protected in any meaningful way, marches through Pierce, through Meyer, and points out that this kind of straw man of this boogeyman, rather, in Lochner is incompatible with how you look at how 8 of the 9 justices resolved that case. Can't be scared of judicial engagement. That's just a genuine pursuit of the truth on the behalf of actual facts and evidence. And it's good to see jurists engage with these constitutional questions and not merely pull out their rubber stamp, because the rubber stamp is what kept unenumerated rights unprotected for far too long. And the rubber stamp has worn out. It is worn out. And it's important that jurists get their arms around these deeply rooted, meaningful rights like property rights and economic liberties and the ability to raise your children and direct their education. These are foundational to the American experience and to a free society. And it's a great talk with a very refreshing reception from many conservatives in the audience. There were several hundreds of people that were applauding Mr. Barnett.
And we'll put a link to that video in the show notes for folks who want to watch that debate. This issue of substantive due process and parental rights and trans issues is super interesting. Of course, super controversial, but also super ironic in, I think, how it's going to play out. And I am not the first one to say this. Luke Berg of the Wisconsin Institute for Law and Liberty. I was at an event a couple of months ago, and he pointed this out, that there are right now in different states very concerned parents raising these claims for exactly the opposite type of issues. So there are parents like the parents here who don't want their schools, not telling them when their own children are picking a different gender at school, and so they want to know about that. And that is that's actually an issue. I should alert listeners who are interested. We talked about a similar case like the one Braden talked about from the Fourth Circuit a few months ago, but the court found everything. There was no standing. Basically, everything was a John and Jane parents versus Montgomery County Board of Education. We'll put a link up to that episode also in the show notes. But so there are these types of cases, and then there are cases in states that have enacted laws that are prohibiting gender transition in some kind of way for children, and the parents want their kids to do whatever it is, whether it's hormones or the surgery or whatever about affirming their gender, and are challenging those laws based on this same theory, based on these two cases that we've talked about short circuit many times, Pierce and Meyer from 100 years ago, about the scope of your rights as a parent to control the upbringing of your children. And so a clash of these two different lines of cases, both using substantive due process, is going to be perhaps coming in different circuits, maybe the Supreme Court in coming years. And this is on top of all this, challenges that substantive due process claims have. Whatever you feel about the abortion issue itself, it's fair to say that there are challenges based on the Dobbs opinion in that region. So a lot of interesting parts in play here. The other thing about this case I found kind of weird, but it didn't really come up. And I think maybe it's a case of a court not worrying too much about a step because it was going to get after that step anyway, is in when the court is looking at the vagueness challenge and the majority is dealing with the vagueness challenge. They first do standing. They say, as you explained, Braden, that the parents had standing, and so they could move on to whether this policy was vague or not. But in talking about whether there was standing, they basically were saying, well, there's a colorable argument here. Like, it looks like you might win, so you have standing. That's not how standing's supposed to work. Standing's supposed to be, do you have a cause of action? Do you have a right? So they could have claimed something like, so to bring up an example that true First Amendment lawyers everywhere hate, I want to go into school and scream fire right when class starts, so everyone has to run out of the building. And yes, I want to do that. I know it's for no good reason, but I want to do that. You have standing to bring that claim. You will lose 100% in that there's no First Amendment right to yell fire in that way. Or to, all kinds of other things that might be covered by this policy. But it doesn't matter for the merits whether or not you have standing. And the court just kind of is like, oh yeah, you got kind of a chance here, so let's get forward to the merits. And you win. And that's not how it's supposed to work.
Yeah, among other things, kind of makes the preliminary injunction sort of the end all be all, right? Like
right.
I'm not sure where this case currently stands, but yeah.
One thing that I was happy to see in the Eighth Circuit opinion relates to enforcement. Sometimes a law will hit the books, and you can tell this thing was just a product of red meat politics at the legislature, and then the state will defend it, saying, "Well, we're not really enforcing it yet; it's too early." And this is kind of something they throw out there to kind of ding your standing. They're trying to knock the legs off the stool where the merits sit. And the Eighth Circuit says that the general rule of statutory construction is that one of the general rules rather of standing, not statutory construction. That's what we're going to get to in a moment. But is when there's a credible threat of enforcement. When is that? And when a course of action is within the text of a policy, there's a credible threat. And the district had argued that the policy was only enacted recently in 2022, and there's no real credible threat of enforcement. But the Eighth Circuit kind of flipped it and said, no, the policy was enacted only recently in 2022, and there is thus no established practice of non-enforcement that would satisfy the concerns about those that are subject to the law and about the imposition of discipline. And that's right. The law is on the books. It threatens people's rights, and the government can get out of a case on standing by pointing to the lack of enforcement or non-enforcement. It's on the books, and if it's recent, the mere fact that there's no established practice of non-enforcement is what should govern whether you have standing here. And here it was, they're kind of walking through and knocking down the different arguments of the district.
Yeah, and the Eighth Circuit's been pretty good on that for a while, even since Clapper. They've kind of said, absent non-enforcement, if you're within the scope of a law or a policy, that's when you bring pre-enforcement challenge. But that's, to me, I think fairly obvious. Otherwise, why have a pre-enforcement doctrine at all if that doesn't qualify? But that's not how all other circuits see it. I mean, the Sixth Circuit, among others, very much clings to the Clapper standard. It is very hard to figure out when you can bring a pre-enforcement challenge short of actually being injured, which, kind of defeats the purpose of the chilled speech doctrine for First Amendment purposes, because most people are simply going to chill their speech rather than risk penalties. And if you've got to risk penalties and have it certainly be impending before you can challenge it, why not just self-censor? Arif, you made a good point about kind of the gamesmanship about enacting a policy and then defending it in a different way. So, the oral argument, one of the things that actually occupied a considerable amount of attention was they were challenging the issue about parents not being notified about a gender support plan in their kids' files. And the policy itself says the student has the ability to decide if the parents are going to know about this, and it'll be kept confidential unless the student consents. However, it's got a proviso in there that says, unless required by state or federal law. And the government attorney spent considerable amount of time arguing back and forth with the court that, well, we're required to give student records to parents under FERPA. And you can easily imagine a scenario when that would be persuasive. Of course, probably people are listening right now screaming through the mic, like, what's the point of the policy to begin with? If in all cases the parent still has the right to access the records. And I do think that the judge draw here was sufficiently incredulous of that claim that they really kind of pushed in on that purported claim that we enacted this policy to keep these records confidential, but it doesn't actually mean anything when it comes to the parents because of the state law, even though we wrote in there that the parents need the consent of the student. But that's the kind of thing we all probably seen a time or two.
Well, and that's the kind of argument that defense counsel for the government are paid to come up with.
Yes.
We're now going to shift from the First Amendment and free speech to property rights and property law. And this is an area of property law that I have to say I know almost nothing about. But Arif is going to walk us through it. And it actually provides some fascinating questions and issues that we're going to be getting to in our season of Bound by Oath, which is just starting. If you check your podcast app, you may, when you're listening to this, also have the first episode of Bound by Oath ready to listen to, which is all about property rights this season 3 of Bound by Oath, and our good friend John Ross. So check out that and these issues coming up this season. But first, Arif, this is about oil and gas. And the thing about oil and gas is, I guess it tends to move around under the ground. And so it's a little different than your average piece of property. Is that right?
That is right. You learn about the surface estate in property rights in law school. You also learn that there's a mineral estate, what's underneath the surface. And a lot of people down in Texas, for sure, where I'm at, but also in Louisiana, where this case arises from, own property and retain the mineral estate as part of their property interests. So I guess the best way to tee up this case, because it involves oil and gas law, it involves property owners with mineral estates that haven't agreed to sell any of their mineral estate, any of the oil or gas underneath. It involves Louisiana's relatively new conservation law, which I'll get into in a moment. And it involves this deeply rooted doctrine called negotiorum justio.
Excellent Latin pronunciation, by the way.
Oh, merci, monsieur. Merci. This Frenchman will reach into the Latin roots of French to try to get it right. And it involves statutory construction. And statutory construction is where the panel splits. And I'll get to that split later at the very end. I'll tell you who's on the panel. On the panel were Judges Dennis, Elrod, and Ho. And this case is Johnson et al. On behalf of himself, Linda and James Johnson, and other similarly situated members of the class, versus Chesapeake, Louisiana LP, and Chesapeake Operating, which is this Louisiana subsidiary of Chesapeake, an oil and gas operator. And so this case concerns the interplay between Louisiana's relatively new conservation law and its deeply rooted negotiorum gestio doctrine. And it arises when Linda and James Johnson, who own land in Louisiana, who also own the mineral interest under the surface, so the oil and gas under the surface of their property belongs to them. And according to state law, they were forced into a forced drilling unit. So there's a couple of things I want to set the stage with. And one is, what is that? So if you know about oil and gas law, unitization is something that is often addressed in the law. It creates rules to try to conserve, from the state standpoint, oil and gas and efficiently pump it out. And so unitization is part of a conservation law, including Louisiana's, and it refers to combining separately owned mineral interests, like the Johnsons. Some may be leased to the driller. Some may, like the Johnsons, are not leased. But regardless, they're combined into a common supply or reservoir. And they do this to create a joint operation with one driller to maximize the production and maximize operations. And it usually involves a pretty large area. And you can be either voluntarily part of the unitization or you can be forced into it. The Johnsons were forced into it under Louisiana law, under their conservation law. And so some people that were part of this unitization of the oil and gas under their property and other neighboring properties agreed to be part of it. They have contracts. Those contracts with Chesapeake say, here's what we're going to pay. They say, here are the costs we're going to deduct for pumping this stuff out. And, they also address post-production costs, bringing it to market. The Johnsons, however, don't have a contract, but they are part of the pool. And under Louisiana's law, you have to be paid for your pro rata share of what's extracted from the unit based on how much property you own that's combined here. And you have to be paid within 180 days. And the statute says you, driller, operator, Chesapeake, can deduct production costs. It's silent as to post-production costs. So the dispute arises between the Johnsons and other class members and Chesapeake because Chesapeake decided to, pay everyone, the contracted lessors, and also the ones without a contract, like the Johnsons. But they deducted not only production costs to get the stuff out of the ground, they also deducted post-production costs. The statute is silent about this. The Johnsons are seeing the value of their mineral estate diluted by post-production costs, and they never agreed to post-production costs being deducted. So this goes to court. And in the district court, the plaintiffs, the Johnsons et al., received a partial grant of their summary judgment motion. Chesapeake, not liking that result, filed a motion for reconsideration. And unlike a lot of people, they prevailed on that motion for reconsideration. And the motion for reconsideration led the Fifth Circuit panel to hold 2-1 that the quasi-contractual doctrine, I'm sorry, not the panel, but the district court, that the quasi-contractual doctrine of negotiorum gestio provides a mechanism for Chesapeake to properly deduct post-production costs. So what is this doctrine? Well, this doctrine is very different than the unitization law. Louisiana is the only state, like I mentioned, that actually employs this doctrine. It has deep roots, but under the doctrine, there's a few things that have to exist. The proposed gestor, and here would be Chesapeake, would need to proceed in a way that I think is consistent with what the historical roots of this doctrine are. So to give you an example, let's say you live in a hurricane path and you're not home in Louisiana, and your neighbor decides to stay put. It's a category 1. But you've left town, and then your windows are smashed. So the neighbor walks onto your property, brings his plywood, nails it on the wall to protect your property. That act of trespass is protected, even though they had no authority, under the doctrine of negotiarum gestio. And it's a doctrine that is rooted in altruism. And that person that went and put wood up on the windows that were smashed can recover, under a theory of unjust enrichment, the cost of doing so. So there are certain legal requirements, though, to fall within this doctrine. One is that you have to act, the gestor, and here Chesapeake in this case, you have to act voluntarily and without authority. Second, you have to be protecting the interests of another, not your own. And you have to have the reasonable belief that the owner, your neighbor, if it's a hurricane, or here, the Johnsons, would approve of the action if they're made aware of the circumstances. And the circumstances here is post-production costs. So the way that Chesapeake wins their motion for reconsideration is by shoehorning post-production costs and their ability to deduct them from the Johnsons' take of their mineral estate in this ancient doctrine that is grounded in this idea that you're just trying to help people and are just recovering costs for helping them. And so this hits the Fifth Circuit, and there's a split in how this comes out. Two of the judges believe that you can't answer this question. Does negotiarum gestio provide Chesapeake with a mechanism to allow it to deduct post-production costs? Or are they bound by a more narrow, a more specific statute, the conservation law, which spells out exactly what can be deducted at the wellhead, is silent as to post-production costs, and makes pretty clear that unitization is the law in Louisiana. You can be forced into this process, even if you don't have a lease, but you got to get paid. You got to get paid within 180 days. And if you're not paid within 180 days, even the production costs before reaching the wellhead can't even be deducted. So that's the lay of the land. So what happens at the Fifth Circuit? Well, like I mentioned, there's two of the judges agree that negotiarum gestio is a deeply rooted doctrine. The parties agree that whether you look at this case through the lens of the unitization conservation law or through negotiarum gestio, you're basically dealing with quasi-contractual relationships. The Johnsons have no contract, and unlike the other people that are tied in this oil and gas unitization, their relationship with Chesapeake is quasi-contractual. It's rooted in what the statute dictates, or in this relationship, negotiarum gestio, which the Johnsons say does not apply. And so two of the judges want to send this to the Louisiana Supreme Court. But a third says, no, we can answer this quite easily. We're not making an eerie guess. We could just apply principles of statutory construction and reach the answer that we need. So the dissent opens up by saying, look, a unit operator like Chesapeake can sell the owner's production under statutory authority, but cannot be a gestor. Why? Because a gestor under negotiarum gestio, as the code makes clear, is someone who acts, quote, without authority. Chesapeake is engaging in unitization pursuant to legal authority under state law. But this doctrine, as the threshold requirement, requires that someone act without authority. And the dissent criticizes the other two judges by saying, by certifying this question, we're basically disregarding just the plain text of Article 2292 in this case, which lays out how you can fall within negotiarum gestio, and basic rules of statutory interpretation. We have a more specific statute. It should govern. The dissent cites case law, oil and gas cases in state court that show that, especially in the oil and gas context, statutes that are more specific govern. And in any event, we can just read the statute and easily conclude that you need to be operating without authority. And Chesapeake is doing the exact opposite. They're pursuing unitization under state law. And so it is true that the statute did not specifically address whether you can deduct post-production costs. These are costs after the minerals are reduced to possession. So taxes, transportation, dehydration, treating, compressing, gathering. The statute is silent about that. But negotiatorium gestio seems to be a mechanism that can't get Chesapeake where they want. They want to be able to deduct costs that benefit them as well, not just the Johnsons, benefit everybody else that's part of this pool, not just the Johnsons. And they want to do so by invoking a doctrine rooted in altruism where you're trying to help your neighbor.
Yeah, if you're being
interests.
sued, it doesn't seem so altruistic anymore. That's just my take.
So that's where things go. And this is going to be resolved ultimately by the Louisiana Supreme Court, which will pronounce whether and how negotiatorium gestio applies in the unitization context, in the context of Louisiana's conservation law. And I think, where I come out on this, my sense is that the dissent got it right. You've got an oil and gas conservation law. It provides a unique quasi-contractual relationship between unleased mineral owners and operators like Chesapeake. And just using basic rules of statutory interpretation, you can apply only the specific provision that allows for unitization, speaks to the deduction of production costs, but not post-production costs. And that is a statute that confers legal authority to engage in unitization and start pumping even from mineral estates that you've never leased. And that should govern. And so the proper outcome is clear. I agree with the dissent here. I don't think it's necessary to go to the Louisiana Supreme Court. That was Judge Dennis who dissented. The majority is Elrod and Ho. Now, maybe there's a reason that'll cash out at the Louisiana Supreme Court, and that is, how deeply rooted is this doctrine? Now, we know it's deeply rooted in ancient Roman history, and there it was rooted in helping your neighbor, protecting your neighbor's property when they're away. And perhaps
something the medieval Normans were renowned for doing.
and perhaps in Louisiana, with the oil and gas, the historical aspects of oil and gas exploration and drilling, that there is evidence reflecting a deeply rooted historical tradition of applying this doctrine. Although I'll be surprised to see it, to deduct like the marketing costs of selling the oil that's leaving someone's land. I could see capping a well that has popped to save the oil and keeping it underground. But pumping it for someone just to be nice to them and then deducting all the costs seems a step further. But maybe there are examples of that. And that's what the historical understanding of that doctrine in Louisiana, at least, is. So we're going to find out once the Louisiana Supreme Court has a say. I will say that having weighed in on IJ's behalf as amici in the Louisiana Supreme Court in a case involving eminent domain and the taking of a port that was a private port and taken to be by a public port operator, that I was kind of shocked at just the departure from textualism and property rights protection in that case involving eminent domain at the High Court in Louisiana. And that case was Violet Dockport. And, my hope is that property owners like the Johnsons get a reception from the court where their property rights are properly cast as deeply rooted in history that predate this conservation law, and that, when push comes to shove, you should ultimately side with the individual property interest. Now, Louisiana is different than the other 49 states, and maybe that's not going to happen there, but we will find out soon enough. So we have a 2-1 split with a certified question headed to the Louisiana Supreme Court in Johnson v. Chesapeake.
So, Braden, 2 questions. How deep is your knowledge of ancient Norman oil and gas law? And second, have you ever tried to certify a question from a federal court to a state court?
Yeah, so on the first question, I would probably have to say it's probably a little bit less than you might suspect.
All right. Okay.
Yeah, I mean,
Well,
it's not exhaustive. I think I took a survey course in law school, but since then, nothing. So I have to
maybe in
study for the
middle school
bar.
with that French you learned.
Right. Yep. I am a little bit. I mean, I do watch the Vikings show on Netflix, so I'm a little bit in the neighborhood. But they didn't talk about this doctrine. I suppose the only reason why this exists in Louisiana is this a throwback to like the French Civil Code, I assume. Is that right, Arif?
Yes. Yeah. And you see this type of doctrine prevalent in many European countries, including France, civil law systems. But it's definitely not something that's grounded in the common law.
Right.
And that's what permeates the other 49 jurisdictions in
Yeah,
this country, 49 states, the laboratories of liberty, as I like to call them.
So because of the French, somebody can undertake an act ostensibly on my behalf that I do not want them to do. And then when I don't pay them for it, they can sue me.
Under a theory of unjust enrichment. That's correct.
Yeah. This is I don't understand how this stuff still exists in America. I thought we fought 2 world wars to get out from under the French thumb. I mean, where am I wrong about that? What am I missing?
And in defense of the French, and I know nothing about this other than what Arif has said and what Judge Dennis says in his dissent, which I'll touch on also in a moment. But I get a sense that what's going on in this case is quite the perversion of this doctrine, which should be about examples like Arif gave about a hurricane and helping your neighbor out. When you get to the point of there's a lawsuit, it does seem that this doctrine has kind of outlived its altruistic usefulness. But this property law issue is fascinating, and I think so. To give shades of what we're going to talk about this season on Bound by Oath, there is, and this also relates to this case we had from my state here of Minnesota that many listeners know about, Hennepin County versus Tyler, which was the case at the Supreme Court last year about the woman who had a condo, and there was a fine, or her condo was taken for not paying property taxes and sold, and the county made a profit of it and didn't give the excess back to her. And so the argument was, well, state law just says that this is the law, that we get to keep it, and it's just the definition of property. And the court said, no, you can't make an end round around property rights by just defining property differently at the state level, even though usually we look to state law to define property rights. Here, I see kind of like the absolute opposite end of the spectrum, which is that we all realize that over time in a common law system, that definitions of property and understandings of property can change. And that's not necessarily a taking, right? If our understanding of what you own now is different than 200 years ago, it's not like the courts had a taking over that time. It's just law changes to some extent over time. And I see what Louisiana legislature did here by moving away from the old, like it says, the Judge Dennis explains, the old capture idea. So there you would have like 4 different adjacent landowners all pumping as hard as they possibly can to get the oil out, because you get whatever you capture. And this tries to, more collectivize it. I mean, I say collectivize it. I think they would say rationalize it, so you don't have that problem. Now, maybe when that was enacted, that was some kind of a taking, maybe not. But it's a lot more understandable way to kind of like refine property rights, but also still allow the original property owner, right, like the plaintiffs here, to get their share. It's just it's rearranged a little bit how that comes about. Mm-hmm. So I see this doctrine as kind of like, coming in to make a bit of an end round around that, what the legislature was trying to do, to give more of those property rights to the driller than was probably foreseen. And so I am supportive, I guess. I looked around a little bit online. It seems like that motion for reconsideration of the district court had all these amicus briefs from all these oil and gas interests, which is kind of unusual for a motion for reconsideration in a district court. So this seems like a big deal to the oil industry, which brings me to my theory here. So tell me if I'm wrong, Arif. My theory is that maybe the three judges are more aligned here than we think, and that they're like, okay, because there's another case coming up. So I imagine these issues are coming up all over Louisiana. The Louisiana Supreme Court needs to sort it out. They haven't. And so the Fifth Circuit, if the Fifth Circuit rules, well, that's not the law of Louisiana for the reasons you gave, because it's a state law issue. It's just going to be the law in the Fifth Circuit. And so they want the Louisiana Supreme Court to sort out this mess. But at the same time, they can Judge Dennis says, well, I think the answer is pretty plain. So Judge Dennis is kind of the fall guy who does a dissent, which is like, here's how you should rule, court. The other two judges say, we're not really sure, we'll send it along. He could have done that as a concurrence, but I think that one it would look more funny, because it's like, well, I think the answer should go to the Supreme Court, but also I think the answer is this. So he's the one who takes the dissent. The other two send it to the court. And now Louisiana Supreme Court kind of already has this amicus brief from this Fifth Circuit judge, which makes it harder to just kind of go into what the oil and gas industry wants, which seems a little bit more devious by my limited knowledge of the law. So do you agree with my conspiracy theory, Arif?
I do. I agree that I agree with it to the extent that this is an easier posture to lay out reasons by dissenting, as opposed to concurring to a certification of a question and then basically answering it. And so, yes. And frankly, I also agree that I think Elrod and Ho want to put this to bed. I mean, they realize that there is historical aspects to this doctrine that may be unique to Louisiana, because the doctrine is unique to Louisiana, and respecting the Louisiana Supreme Court as the highest court in Louisiana from a state law standpoint, kicking it over to them gives them the opportunity to brief the deep roots that this doctrine has, including the Johnsons' ability to show that it doesn't extend to what Chesapeake is trying to do here. And so perhaps that's where the three landed. And I agree with you. I think they probably see this, and these are serious judges. They're good judges. They understand statutory construction. And this is interesting, I think, when it hit the chambers. So I think that this is a roadmap, Dennis's dissent, to what the Louisiana Supreme Court should probably do with this. I mean, look, this doctrine requires, as one of the requirements under Louisiana Civil Code, that you have to have Chesapeake would have to have a reasonable belief that the Johnsons would approve of the action if made aware. I mean, you could just the fact that they've drawn swords in federal court is enough to say that they are not approving, and that's it. And I don't think you need to overuse these doctrines to try to do end runs around what law clearly articulates.
Well, to be clear, they didn't choose to cross swords in federal court. They chose to cross swords in state court.
Right.
Chesapeake
and they got
removed them.
Right.
That's right. Yeah.
And one other tea leaf that I see is that the majority say at one point, well, the lower court and this one other lower state court think that it applies, but the scholarly dissent provides cogent reasons to think it does not, which is not usually the kind of treatment that a majority gives its own dissent. So I thought there was something there. But there was a lot here today on Short Circuit. And so I'd like to very much thank Braden for coming on and giving us some of his expertise. We'd love to have you on again sometime. And Arif, as always, thank you for joining us. And for all of you listening, we hope that you listen to the next podcast, and also Bound by Oath, which is coming out imminently. But in the meantime, that all of you get engaged.